SJC-11390, the Woodward School for Girls, Inc., the City of Quincy.
Thank you.
May,
You- 1 second. Just going to get the clock running. Okay,
yes, Your Honor.
go ahead.
Thank you. May it please the court, my name is John Leonard, and I'm privileged to represent the city of Quincy in this matter. With me this morning is City Solicitor James Timmons. This case is a fascinating case dealing with the juxtaposition of John Adams Trust, which he established in 1822, naming the city of Quincy as trustee for three purposes. One, to build a stone temple, which later became the Church of the Presidents in Quincy Center, where President John Adams and John Quincy Adams and both of their wives are entombed. Secondly, to build an academy, the Adams Academy building, for educational purposes. And thirdly, to fund the John Adams Academy for the study of, principally for Greek and Latin. The case is interesting because it tests the present obligations of trustees, modern trustees, in investment policies dealing with historical trusts. We note that the court did ask for amicus briefs on the issue of a trustee who invests in fixed income securities in a charitable trust to the exclusion of participating in equities. The court question went a little bit further. It said in opposition to the advice of trust advisors. I'm going to argue to you later that the city fully complied with the advice of the South Shore Bank with respect to trustee policies. But in point of fact, as part of a motion in limine which we filed to exclude the testimony of the school's expert, Scott Winslow, a financial expert, we filed a motion in limine, and as part of that motion, we actually addressed the very issue which the court sought briefs on. The motion in limine is Exhibit 16, and it's found at page A259, 266 of the record. In essence, the city argued in its motion in limine that the testimony of Mr. Winslow, who was going to propose that the school was deficient in its fiduciary obligations by continuing to invest in fixed incomes, was irrelevant for 3 or 4 reasons. The first reason, principally, is that a trustee cannot unilaterally deviate from the investment policies as set forth in the trust. The second reason is that the settlor is entitled to make reasonable and rational decisions as to investment policies, which President John Adams did here when he requested that this trust be invested in solid public funds.
This only related to the funds from the sale of the real estate, right?
Well, that's right. The trust from the city, in the course of dealings with the beneficiary here, did secure an opinion from Judge Mulhall, and Judge Mulhall said that, in his opinion, the sale of real estate could be invested in equities.
Didn't that go up also, or not?
Well, I don't think so, Judge.
So it could be in equities, and in fact, it didn't. The city did invest in some equities.
Indeed, they did, but as the record will show, not to the extent that the trial judge required them to invest in. When you have a situation like this, if you wanted to deviate from the intent of President Adams, you'd have to show that the trust that the purpose of the trust was no longer possible, that it was impractical, it was seeking illegal elements, or somehow due to changes in circumstances which may not have been anticipated by the grantor, President Adams, that the trust purposes were somehow being inhibited or impaired. And the record is clear that in this case, and if those circumstances were met, then a petition for cypre could have been filed seeking authorization for the trustees to invest more aggressively in equities.
But if you had just used the proceeds from the sale of of these, what did you call them, scrap pieces or something like
Yes,
that?
they were scrap pieces. They were parts of the quarries which were later filled in.
So if you had just used those monies for investing in equities, you wouldn't have needed to bring a cypre petition, would you?
Yeah, you would not have as long as you didn't take the trial judge's position here that you needed to invest 60% of the trust funds
That would
in
be
equities.
clearly more than, that's what you're saying, that would
Yes, it would have
clearly
been-
be more than what the growth of the real estate sales.
That's exactly right. It would have been significantly more. And in point of fact, the record is rather clear here that the beneficiary, the Woodward School, at no time either complained about the investment policies of this trust and the trustees, even though they had been carrying on with conservative investment policies for 50-plus years, but at no time did they seek a petition for cypre to authorize perhaps the conservative trustees to be slightly more aggressive in their investment policies. And I'm going to suggest to the court respectfully that the evidence shows that the Woodward School could not have satisfied the stringent requirements in order to have the investment policies of this trust altered for 3 or 4 reasons. Number one, the Woodward School became the beneficiary of the trust in 1950. And from 1950 to 2008 or 9, the trustees had paid over $1 million to the Woodward School as part of this income trust. In addition, the special master and the forensic accountant, Mr. Howard Newberg, who reviewed all of the trust documents and records, found that from 1950 to the present date, the average income on the trust was 7.68% per annum, as opposed to similar securities and similar trusts which earned 7.7%, so that we have paying over $1 million, earning at least 7.5% per annum, and the trust paid over the income of the trust for all of those years, with the exception of only $83,000, which was not dissipated but was invested back in the trust for the benefit of the beneficiaries. Interestingly, the special master, Jim McLaughlin in this case, and the forensic accountant both found, as part of their report, that the trustee made prudent investment decisions of the trust assets. And so we arrive at trial on this accounting case. The complaint was a one-count accounting petition filed with this court and remanded to the Norfolk probate court. And we go to try the case, and there's no reference whatsoever in the pleadings, in the complaint, in the special master's report, in the forensic accountant's report, in pretrial memos, in witness disclosures, that somehow this case involves failure to invest sufficient funds in equities, as opposed to an accounting of, was all of the income of this trust paid over to the school as it was supposed to be according to the trust? And secondly, were the expenses of this trust justifiable according to the records of the trust? And I have to confess to the court, and you've probably read the record, the city of Quincy was, in my view, abominably deficient in its record keeping. But in its investment policies, they were well above average. So
is your challenge here limited to the part about these equities? In other words, all the findings about the sale and the various monies not being transferred when it should have been, that's all okay?
That's all okay. The city does not challenge those
Yes, or
findings.
something like that.
The city does not challenge Mr. DiGiacomo's appointment as trustee Regretfully, I was brought into this case to try it on virtually the eve of trial. After looking at the record, I would have recommended that the city resign as trustee because they didn't have the municipal resources and the personnel involved to effectively account for the monies in this trust. But when we get to the second day of trial, the trial judge states those fateful words, quote, "It is inconceivable to me that the value of the fund has not doubled, tripled, or quadrupled in the last 60 years. And on day 3 and day 4, he makes similar statements, and all of a sudden, injected into the case by the trial judge personal belief that the fund, an income fund, which paid all of its income over to the beneficiary, did not appreciate. By definition, income funds, if you pay all of the income out, are not going to substantially appreciate over the years. So the parties had to run out and hire investment advisors during the Christmas season, which both of us did to the best of our abilities. And interestingly, the Woodward School hires Scott Winslow as their expert, and Winslow in discovery proffers an opinion that proper investment strategy for this trust would have been 30% in common stocks and 70% bonds. At the time, in 1973, which was the starting point here, the Adams Fund was invested in 7% common stocks and 93% bonds, and that was based upon the trustees' interpretation of John Adams, President Adams' intent that it be invested in solid public funds, and secondly, on an opinion which is dated January 27th, 1973, from a distinguished Quincy jurist, Judge Mulhall, who advised the trustees that except for the monies gleaned from the sale of real estate, all of the other trust assets will be required to be invested in public funds of either the Commonwealth of Massachusetts or the federal government.
But the city did not do any bookkeeping to identify which funds fell within and without of that limit, did it?
I think that's true as a whole, Judge. But what did happen here is that the trial judge latched on to a memorandum from the trust advisors, the South Shore Bank, which is dated 1973, and he interpreted that particular memorandum as saying that it contained only one directive. And that directive was to invest in 60% stocks, 35% bonds, and 5% cash.
I'm trying to figure out precisely what your argument is. Is your argument that because this was only an accounting, that it was improper for the judge to make that statement and for the Woodward School essentially to seek an amendment to their complaint to bring a prudent investor claim? Or to bring a portfolio mix claim?
The judge certainly had the right to suggest to counsel that he saw an issue which he believed to be important in the case that he thought should be tried as part of the case.
So it's okay for the plaintiff then essentially to have amended its complaint to effectively add a portfolio mix claim.
Yes, but when your Honor checks the record, you'll find that that didn't happen. There is no amendment that I'm aware of to the single count for an accounting. What happened is that as a result of the judge's expression of his personal beliefs as to how the fund should have been invested, that the case somehow took on a life of its own. It morphed into a breach of fiduciary duty case, a negligent investment case, as opposed to the initial case, which this honorable court referred back to the Norfolk Superior Court for trial. And the court when the court suggested that the 1973 South Shore Bank Amendment requested and found that there should be an investment policy of 60% in stocks, that in the view of the city, is a gross misinterpretation of the 1973 memorandum.
The 1973 memorandum does talk about that it is, what South Shore Bank is recommending is a policy of income growth. That's its phrase, income growth. So weren't all these suggestions to enhance the income growth potential of the portfolio?
Well,
of-
absolutely, and the city adopted the memorandum, the policies set forth in the memorandum of the South Shore Bank.
Well, it did, but the letter did have as one of the options exactly this 60, right?
It did, and fairly read, I'm going to suggest, Your Honor, the other two options were to sell off corporate bonds and invest in long-term bonds and invest in higher income bonds, and to undertake a whole upgrade of the bond portfolio. I suggested the court respectfully that the proper interpretation of that South Shore Bank letter, which memorandum, which the judge misconstrued, is set forth on page 3 of that memorandum, right in the middle, where the South Shore Bank memorandum reads, quote, assuming that most of the above steps are taken, a rough restructure of the revised Adams Temple and School Fund would look like this. And then it sets forth the makeup of what they suspect it would look like if you carried out some of these investment policies. Savings 6.99%. Fixed income securities or bonds 66.36%. And stocks 26.64%. So fairly read, this South Shore memorandum certainly did not recommend in any way a policy of 60% stocks and a lesser amount in bonds. Indeed, the trustees of the city of Quincy adopted the South Shore memorandum and engaged in a series of transactions to upgrade the bond fund and to sell off the long-term bonds and buy more short-term current bonds. They followed the advice of the South Shore Bank, and yet the judge continues in the record to characterize what the city of Quincy did was to adopt the policy of 60% stocks, 40% bonds, but not carry through on it. In point of fact, if you read the resolution of the trustees as to what they were adopting the general policies of the South Shore Bank as set forth in that particular memorandum. The judge goes on.
Mr. Leonard, I'm sorry, your time is up, but you can make a concluding statement.
Yes, in conclusion, Your Honor, I suggest to the court that, number one, it was error and substantial error for the court to interpose its own personal investment views that are not borne out by the South Shore Bank or anybody else. And secondly, the other principal defect is in assessing damages against the city going back to 1973. Mr. Winslow basically figured out what the unrealized gain would be, $1,135,000, but he didn't take into account any expenses, any commissions, any management fees to get there. And in that type of financial analysis, it's like it's capitalizing gross income, which the appeals court, at least in the YMCA of Quincy case versus Sandwich, said was error.
Thank
And I
you.
thank you very much for your time.
Good morning, Your Honors. May it please the Court, my name is Sarah Kim, and I, with my co-counsel, we represent the Woodward School for Girls. Disloyal, self-dealing, poor record keeper. These are the findings of the trial court, which ultimately resulted in the city being removed as trustee of the Adams Funds. And despite these findings, the city contends that it should not have to pay for any of the damages incurred from its wrongdoings.
Well, that's not entirely, I thought that it was limited to the
The
one
South
point,
Shore-
yeah.
The South Shore Bank,
Well,
or-
let me find the judge's sort of Q and S or whatever. It's finding 197 and Q through S in particular. It's on page 58 of the addendum in the blue brief.
yes, I have it.
Isn't that really where we're at?
Yes, Your Honors.
So the other, in other words, the other poor record keeping and not paying over income, I thought, I just heard Ms. Leonard say they weren't challenging that.
Yeah, and to the extent that they are challenging the damages, it has to do with the arising out of the the court's finding that the trustee mismanaged the investment portfolio. Now, Mr. Leonard spoke at length just now about how the city actually did comply with the South Shore Bank's recommendation. But, Your Honors, we disagree with that. The trustee voted to implement the South Shore Bank's one portfolio diversification recommendation of 60% equities, 40% fixed income. And that is reflected in both the memo and the April 1973 meeting minutes. Now, the language of the memo, if on the record, it's 2765 through 2768, which is a clearer version of the memo. That memo provides recommendations for diversification of 4 different trusts over which the city was trustee. With respect to the Adams Temple and School Fund in particular, the memo talks about, states that it's providing a proposed portfolio diversification of, as Justice Botsford, you noted, income and growth lines along 40% fixed income, 60% equities. And the memo then outlines the 3 different steps to get to that diversification. Recall at this particular time, there was only 10% equities held in the portfolio.
So let's assume, for the sake of argument, that indeed did propose a 60-40 allocation. But let's assume that a prudent investor would have only invested 20%. Which matters, the prudent investor standard or the 1973 board meeting?
Well, Your Honor, here the minutes and the trustees' actions approving and the recommendation, that set the standard for prudence. And then the question goes from there.
But does it though? I mean, that's I guess the question is, let's assume that what they did was, what they agreed to was imprudent, but the person who actually invested the money invested it prudently. Are they obliged to pursue what they said, even though that would not fit within the prudent investor rule?
Well, with respect to here, the expert testimony was that what the South Shore Bank recommended was prudent.
So you're saying that that the only testimony from an expert agreed that what they did was prudent?
With the South Shore Bank, that breakdown, that was prudent, yes. And so the question is then, so to the extent that the trustee then approved that, what processes do they engage in subsequent to that to assess whether or not they should maintain that breakdown?
But your own expert, Mr. Winslow, said that a 30% equity mix, a mix of 70% fixed and 30% equity, was what the prudent investor would have done. And that's not what the board, according to you, what the board did. So who's stating what is prudent? Your own expert or the 73 board?
What the 73 board approved doing.
Well, how many years is that good for? If in 1973 a board makes a recommendation about a certain formula or division of assets for investment purposes, it may change from year to year. And I remember I think it was in the early 1980s, stocks had plummeted in value, and interest rates on bank accounts was up over 10%. I mean, is there no accommodation to be made for changes over the years?
Absolutely, Your Honor. That is absolutely part of the inquiry, is that once a trustee makes a decision, what do they do from that point on to assess and reassess? And Mr. Winslow also testified, and this goes to your question about actively managing the portfolio. Is the trustee looking at what the market is doing and reassessing whether or not the investment mix is appropriate, taking into consideration what the needs are of the beneficiary? And on the record here, there is no evidence whatsoever that the trustee did any of that.
But what do you say, though? Maybe I'm just misunderstanding, but if the will, President Adams It was his will, or was it it was separate? Right.
Two deeds of trust.
Two deeds of trust. If President Adams said that it's supposed to be invested in public funds of the Commonwealth, or and 60% of the fund value is over, includes some of the original. That is, it isn't just sale of the real estate. How do you square those things?
Well, Your Honor, so the deeds don't speak to what can be done with the proceeds of the real estate, and to your question earlier, there was an act of 1894, which the general court allowed the trustee to invest the proceeds of the real estate in securities.
So,
and
but-
in 1953, what was left in the trust corpus was just 10, or rather, let me step back. The original grant was only land, nothing else. And in 1953, when Woodward was named the beneficiary, the trust was comprised of only 10% of the land, and the rest was a portfolio of worth around $250,000 and some cash. And so, and that portfolio was comprised of equities and corporate bonds and U.S. Treasuries. And so, it is reasonable to infer that in 1953, all of the portfolio could have been invested in securities, because there was all the proceeds could have only come from the sale of real estate. And that comports with the trustees' conduct up to that point. They had been investing in equities, and from 53 until 1991, they continued to hold equities, and also comports with, obviously, as I mentioned, the language of the 1894 General Acts, and comports with the opinion of Judge Mulhall, who was giving advice to the trustees, and he himself also said that the trustee was able to invest in securities.
Well, I guess the fundamental question is, for a breach of fiduciary duty claim, are you in breach if you fail to do what a prudent investor would do, or are you in breach because you fail to do what your investment counselor says you should do?
You are in, well, you're in breach if you fail to do what the Prudent Investor Act says. But in addition here, we're not, our position is not that the trustee was required to follow the South Shore Bank's recommendation. The trustee was required to consider and then vote on their recommendation, and to the extent that they disagreed with the recommendation, they should have, obviously at that point in 1973, not adopted it. But the fact of the matter is, here they did adopt it, and then they, for the next several decades, didn't follow the recommendation, and there's no assessment in the record as to why they didn't follow the recommendation, despite the fact that they voted to do so. And there's no consideration taken as to whether or not are the assets that they're currently holding prudent. And there's no consideration of diversifying the portfolio, no consideration of the needs of Woodward at all.
Let's say that that is what we should be focusing on, that they didn't do a proper job of monitoring. But we shouldn't be going along with what the judge thought was the right thing to do. We should be assessing that from the basis of what this particular trust was supposed to do, which is throw off income. And in light of what its mandate was it, what is reasonable? Was it reasonable what did happen? Or is there some play in that? The expert initially said, well, 30% equities, and then what are the costs associated with doing that? I mean, does it have to be the 60-40 optimal if you really want a lot of equity growth and income growth and growth for future beneficiaries, which wasn't the case here? What is your argument for saying that it was appropriate for the judge to suggest a 60-40 and through that lens have the calculation of damages based on that all the way back?
Well, Your Honor, the basis for that is like the trustee's actions itself. The fact that the trustee adopted the South Shore Bank's recommendation, that set the bar, the standard for prudence of the trustee's conduct. And then from there, the question is, well, what did the trustee do? And here, the record, the trustee didn't do anything.
Well, what in the record supports the judge's finding that there should have been a 60% allocation to equities. And I take it back to 1973.
Correct.
What in the record supports that finding?
The South Shore Bank memo in two specific places. First, the language pertaining to the Adams Temple and School Fund. The memo states that it is providing a quote, proposed portfolio diversification along income and growth lines of 40% fixed income and 60% equities. And that can be found at 2766 in the record. And then later on in the memo talks about a Robert Billings fund and the South Shore Bank's recommendation with respect to that fund. And the language of the memo with respect to that fund states specifically, our recommendation for the Robert Billings fund calls for the same portfolio diversification as the Adams Temple and School Fund,
That was only
i.e.
for 1 year. Wasn't that only for 1 year? For 1973?
No, it's the recommendation for the managing the portfolio going forward.
Open-ended. It's the same allocation for...
Correct.
I didn't, until the world freezes over.
Or until the trustee, there's a decision made that this portfolio diversification is not appropriate. And there's no discussion in the record that discussion ever occurred. So to the Robert Billings Fund language, the memo states that it's recommending a diversification for along the lines of the Adams Temple and School Fund, and specifically states 40% fixed income and 60% equities.
I'm confused. Counsel pointed us to one of the pages of the 1973 memo.
Page 3.
And this would have been 03693, which the memo says, assuming most of the above steps are taken, rough structure of the revised Adams Temple School Fund would look as follows. And it certainly doesn't have a 60% equities position, quite the contrary. What is that?
So these are the South Shore Bank I'm sorry, Your Honor, to answer your question directly, these are the steps that the South Shore Bank was recommending the trustee take in order to ultimately get to 60% equities, 40% fixed income. If you look at flip back to the prior page, on the bottom of page, the Woodward stamp is 6371. It's the first page of the memo. At the bottom of the page, when it first starts to discuss the Adams Temple and School Fund, there's a recognition that the reshaping is going to cause losses, and then sets the stage for a gradual diversification of the fund.
Does the record indicate, does the record contain any information about what communications, I saw the vote saying we're going to adopt South Shore Bank as our investment advisor. Does the record contain any communications from 1953 forward between South Shore Bank and an investment committee or something?
No, there's no record of communications like that, Your Honor.
So we just have this one memo and then radio silence?
There's the memo, and then there's the meeting minutes where the recommendation was adopted.
73, but then
yes,
nothing more?
But there's nothing more other than that. And, Your Honor, that's due to the fact that as Mr. Leonard noted, that the Quincy was a poor record keeper and failed to maintain its burden of maintaining adequate records of its administration of the Adams Temple and School Fund. I mean, the city continued to produce documents throughout trial, which affected the way the trial was conducted.
Well, there's a little bit of pot calling the kettle black there, right? I mean, you did get this expert in the middle of trial.
Your Honor, I would disagree. We disclosed Mr. Winslow in October. The performance of the investments were at issue from the inception of the case. The function of an accounting is such that the trustee puts in information of how they've administered the trust over the past period of time since the last accounting, and the functioning of a trial at an accounting is for the beneficiary to raise issues about the accounting and the trustee to justify what they have been doing with respect to the trust. So the way the trial played out is exactly the way an accounting is supposed to work, where the trustee justifies what they have been doing. And here, because the trustees' record keeping was so terrible, they continue to produce records through trial, even at the near, and it was not a continuous trial. The trial spanned 4 months. Near the end of trial, the trustee had to say, we actually didn't sell a piece of property, which we have because we lost track of it.
Had they been filing accountings, annual accountings with the court since 1953?
No, in this case here, the trustee has never filed an accounting with the court during its entire period of administering the trust.
And was there ever a petition to have the trustee removed for failure to file 50 years, 60 years worth of accountings?
No, there was not. And to that point here, the city of Quincy, as the trustee, essentially controlled the school's financing until 1991. The school was financed by funds from the Woodward Fund and Property, and the city of Quincy was trustee of that fund as well. And at the same time was a trustee of the Adams Temple and School Fund. So we're talking about 2 funds here. And the city of Quincy controlled the school's finances until 1991. So essentially, you have a school that was essentially was in effect under the control of the city. So, and then from 1991 to roughly 2005, the amounts of payments that the school received from the city were essentially consistent. It was only in 2005 that payments from the city dropped, and when the school made inquiry, the city was unable to provide a response as to whether or not amounts for the following year would be the same or would go back to the levels that they were before. And at that time, the school made inquiry, and the city and was first forced finally to seek an accounting.
I take it, and I know your time is over, and I apologize, that you agree that the only thing that the city of Quincy is contesting is this $2,270,000 amount, which is finding 198, that they're not contesting the rest of these amounts that were awarded? Is it,
I'm sorry, Your Honor, I'm just
if you look at
flipping back
page
to
58 of 65
It's in the
of
blue
the
brief.
decision, he's got the judge has put together a laundry list of items. And
Yes.
put financial calculations next to each item. Do you agree that the only thing being contested is the last one, which is a $2,270,000, which is really drawn from finding 198? Are the others uncontested by the city? All these other monies due?
Yes,
Okay, they're uncontested.
yes.
Okay, great. I understand. Thank you.
Thank you.
Thank you, Your Honors.
All right.